Next slide. And there's Chris. This is Mr. Ferry, our IT manager. And you can see, this resident over here would not move. Chris tried to get him to move for the picture, and he said, no, this is my home, I'm gonna stay right here. And he's sitting in the benches, relaxing, where he should be permitted to go, and per the resident agreement, he's allowed to go.
Well, again, let me explain. This is a standard licensed assisted living facility, non-memory care. It also has independent living attached on the same campus. This case involved a 97-year-old lady who was alert-oriented, fiercely independent, and she ambulated by an electric scooter. And what happened was she came out in this courtyard around here, and she fell off the scooter at some point in time in the afternoon.
Well, we're not sure if she fell.
So we don't know if she fell or got off it. But
there's a dispute, because one person said the scooter was on its side. The person that found her said the scooter was upright. Did she get up to transfer herself to the bench, which she did every day that she was there, either in the front or the back? This was the back courtyard. There was also a front courtyard with also a beautiful setting. So did she get up voluntarily? She might have. Nobody knows. Nobody saw what happened. That said, she did end up on the ground, and she was found, and they claimed at first 6 hours later, then it was 4 hours later, then it was 3 hours later.
in July. This is July.
Thank you. Yes, it was July 5th. So, and they hired a weatherman, MIT meteorologist, who talked about how hot it was, and that literally was by cross. So it's hot in July. Okay, thanks.
Yeah, it is.
Chris.
So the law of assisted living, we know. What is the purpose of what we do? You know, it's the least restrictive, most home-like environment to encourage the development of facilities, and I hate that word because it really does not describe what we do, but we're an assisted living facility that promote the dignity, individuality, which I think is so important, privacy, and decision-making ability of such persons, also so important, to provide the health, safety, and welfare of residents of assisted living facilities in the state. The legislature recognizes that this is part of the continuum of long-term care, and to support the goal of aging in place. Assisted living facilities should be operated, regulated as residential environments with supportive services and not as medical or nursing facilities. That is what gets blurred. People don't understand that. Lay people don't understand that. The services available in these facilities, either directly or through contract or agreement, are intended to help residents remain as independent as possible.
And by the way, this lady was a resident there for 10 years. So she was well known by the staff.
And to maximize a person's dignity and independence and permit them to remain in a familiar, non-institutional, residential environment for as long as possible. Such services can be provided by staff, volunteers, family, or friends, or through contractual arrangements. Assisted living facility means we provide housing, meals, one or more personal services. And what are personal services? We provide physical assistance or supervision with activities of daily living, and we all know what that is. So this was the focus of this entire case. This entire case was about supervision. Daily observation, what does it mean? Daily observation, daily is not defined in the statute. The word daily is not defined. It shouldn't have to be, but we are lobbying at this point to have it defined because it became a big issue in this case. And people just blur the lines and don't understand. So daily observation by designated staff of activities of the resident while on the premises and awareness of general health, safety, physical and emotional well-being. Maintaining general awareness, also not defined by the statute, rules, or regulations. So these are somewhat vague terms. And then the resident may travel independently in the community. This became a huge area of conflict in this case.
Yeah,
Okay, are you awake?
Hello.
Okay, you might want to open the bottles of alcohol.
No, the definition of community became critical in this case. Community, does that mean on campus or does that mean outside of campus? That became a huge issue, surprisingly.
And so those were the three major issues in the case. You know, what does daily mean? What does general whereabouts mean? What is community and traveling independently in the community mean? Okay, so we look at the 1823. This lovely lady was independent in everything, including ambulation with the use of a wheelchair or motorized scooter, which, by the way, she ran on rabbit. She would, if you didn't see, she expected you to see her coming and get out of her way. And she was alert and oriented ×4. I'm pretty sure I'm only ×3. So.
And the only thing she got assistance with, as you can see, was with in and out of the shower.
Right.
And we did bed passes for her.
But she refused that.
Yeah.
She refused help getting in and out of the shower. She would just bathe herself at the sink, and that's her right. You know, they have on the 1823 general oversight, so you would think observing whereabouts. What does that mean? General whereabouts, right? Daily whereabouts. In my opinion, that's your residents' routines. You know, if they don't show up to a dining event where you have your checklist to make sure that you're keeping track of folks, which you don't have to do, but it's a really good best practice, and I encourage us to continue to do it, then we go look for them. And where do we look for them? This lady would look out in the courtyard, because she typically wanted to sunbathe and read her Bible. That's what she did. So we knew where to find her. So the residential agreement, very important. Please look at your residential agreements and make sure that they reflect the law. Residential agreement here, clearly entitled to use of apartment. We clearly say we are not a healthcare provider. We are a senior resident apartment community. Perfect, right? Because that's what we are. You're entitled to have your apartment. We have a 24-hour emergency response system located in each bedroom and bath. You are entitled to an unlimited use of all common areas. Wouldn't that be the courtyards? Right? Sure. So the one issue that really became a big issue was this 24-hour emergency response system. Pendants became an issue. We had pendants, they worked in the apartment. They didn't work outside. Some pendants work outside, some don't. And the claim was that people didn't know where they were, and that there was a sense of security, thinking that they worked outside when they did not. And that was a big area. Now there's something called the undertaking doctrine. We're not required to have pendants. There's no rule or regulation law that requires us to have pendants. But when we have them, we have to use them and reasonably use them and reasonably have systems in place relating to them and educational systems in place, in services, making sure that we're in servicing the residents and the staff and some documentation of that. That we did not have in this case. So that was a big deal. But once you do something affirmatively, you have to do it reasonably, because then a duty is created under Florida law. So that is something to keep in mind. We're not required to do many things, but when you do it, we got to do it well.
All right, Kirsten, we need to start rolling. We only have 17 minutes.
Go. Let's go. Move this. Okay, move it. Okay, we have the service plan. Move it. Again. Go.
Please rise. Court is now in session. Judge Seymour Watson presiding. The People versus Fielding Milledge.
I object, Your Honor. This trial is a travesty. It's a travesty of a mockery, of a sham, of a mockery, of a travesty, of two mockeries of a sham.
Accurately describes the case. Okay, so daily observation, let's go. This was the testimony of the plaintiff's expert administrator who works for us.
Well, it doesn't work for us.
Well,
Works for a facility.
works for a facility in a
This is actual deposition and trial testimony, and we want to read this verbatim and read it quickly because it is important. Question: do you understand the word daily? Answer: daily means throughout the day. Okay, so in your opinion, it's not that they've seen the resident, they know she's safe, they know generally where she is. If you generally know someone is in the facility, you're saying that's not enough. Answer: well, it doesn't say once a day. It just says daily, which I would interpret to mean throughout the day. Witness: it is my testimony that the staff needed to have an awareness of where she was throughout the day and they needed to be laying eyes on her every 10 or 15 minutes to make sure she was okay. Kirsten asks, so just so we're clear, in light of the interruption, it is your testimony that with Miss So-and-so, we can agree who was alert-oriented, correct? Correct. We can agree that she was cognitively intact, correct? Correct. So, under any, my understanding is you will tell this jury, your opinion is that under any circumstances of any weather in regard to this resident, if she went outside on the front porch or in the courtyard area where she was on July 5th of 2017, that some staff member would have had to lay eyes on her every 10 to 15 minutes. Yes, they need to be in the line of vision. And if they did not do that, that would be a violation of the standard of care. Yes.
Can we all agree that's not the standard of service? Okay, thank you.
Continuing, daily observation view means continue to know where they are and keeping eyes on residents, each and every resident throughout the entire day, despite the fact that this is an assisted living setting. Yes. If a resident wishes to go out in the courtyard, they may do so if they wish to do so by themselves, correct? With supervision.
Someone needs to babysit. That was the testimony.
I'm sorry?
Is this the ED at this?
No, this is the plaintiff's retained expert that is an ED at another community.
A local community, though.
Okay, so if it's 70 degrees and it's a nice sunny day, how often does the standard require the assisted living committee staff to lay eyes on this resident? Answer, I would still be checking on everybody within 10, 15 minutes because things happen and you've got to keep an eye on people. So, and again, here it is.
This was the area where she was found. She came through and sat by the pond, and then she came up, and this is the circle where people walk their dogs, where this gentleman was sitting, and she either fell or got her foot off her scooter right around here.
More testimony. You would agree that assisted living residents do not require round-the-clock monitoring? No, I disagree. Okay, if you have no knowledge of any incident or accident ever happening in the area where you are indicating the landscape of blocking the line of sight from the first floor, correct? Yes, but then you have the facility knew that the area could not be viewed. Why would you have residents being able to access part of the property where they can't be supervised?
Now you saw the area. It was lovely landscaping.
So we did the math. 10 to 15 minute checks, assuming 50 residents.
No. There were 60 residents in her facility, and she said most of them were fall risks. So I said, okay, I'll give you the benefit of the doubt. We'll only take 50. And then she said, then 10 to 15 minutes, you have to look, you had to lay eyes, right? So I said, okay, we'll take every 15 minutes. And then we did the math. Well, Chris did the math. I read the math. Go ahead.
Yes. And basically over an 8-hour shift, there'd be 1,600 resident checks. Every shift, 1,600 checks. 200 checks per hour. So, go ahead.
That was the no staff shift. That was the day shift. That was the day shift. We had the most staff on that shift. So we took the most staff shift and did the math on that shift to answer your question.
Chris, let's go to the next slide. Okay, definition of the community. You can go off the premises of a facility by the resident care standards as defined by Florida Administrative Code, correct? Yes, it just says travel independently in the community. Question, the community, you're going to interpret that as being within what, the campus of the facility, within the facility, outside of the premises of the facility? How do you define that? I'm thinking the campus. So outside the doors of the facility, but not off the premises of the campus, that's how you're defining that. That's my interpretation, yes.
So despite the fact that the residency agreement actually provides parking spaces as well for our residents who have cars, you can't leave the premises. At least not without an escort.
Despite that law regarding the right to travel independently in the community, it's your testimony that there is no resident in an assisted living community that can go off the facility premises and go to a restaurant or Publix or a mall or something like that without an escort, correct? Correct.
I'm sorry to disappoint you, but I've known Fielding Mellish for years, and he's a warm, wonderful human being.
Would the clerk read that statement back, please?
I've known Fielding Mellish for years, and he is a rotten, conniving, dishonest little rat.
Okay, I just want to make sure you were getting it.
You're out of order.
ACA DCF came in, and she had to admit that we were cleared by both ACA and DCF for the claim of supervision. Of course, none of that comes into evidence in this jury trial.
Understand that ACA and DCF are hearsay documents, and so when we have them in our favor, they are not admissible unless CMS says we can take the deposition of an ACA person, which only happens if they, in their discretion, thinks it is in their best interest, which is, in the old days, we actually called ACA.
We can thank George W. Bush's administration for that, by the way.
And we are Republican. Go ahead.
Independence of residence, of the resident. Okay, on the 1823, that specifically identifies, for example, Ms. Resident as being independent in every areas of activity of daily living, with the exception of bathing, correct? That would include ambulation, correct? Correct. And she ambulated by a scooter, or she walked in a room as well for short distances, correct? Correct. And she was found to be independent in ambulation while using her scooter, correct? Yes, correct. She was found to be alert-oriented times 3, correct. But it is not checked off that Ms. Resident needs supervision with ambulation, correct? Correct. Is it your testimony that to this jury that in a person with an unsteady gait, providing them with a scooter does not qualify as a fall precaution? I would say no. I don't usually consider a scooter fall precaution. I don't know what it is then. They did not check off that she needs supervision and ambulation by scooter, correct? Answer, but she needed supervision because of her high risk of falls. Question, I mean, for example, in Kay's case, one thing that made her unique is that if she fell on the ground, everybody knew she could not get up on her own. Is that fair? Correct. Now, this is questioned by the plaintiff lawyer. And this is where they took this case, was taking the 1823, saying it doesn't address the ability to get off the floor and creating a new standard of care.
So if you fall and can't get up, then you have to be supervised at all times.
Exactly. So here's more question about plaintiff lawyer. But on that particular piece of paper, talking about the 1823, there's no label where it says ability to get off the ground on your own. That's not on that piece of paper, right? No, it's not. Question, that piece of paper that keeps being shown to you, talking about the 1823, out spot where it says ability to get up off the ground when you fall, it wouldn't be checked off independent for Ms. K, would it? No, it would not. In fact, it would be checked off total assistance required. That's correct.
And that was a theory. If you fall and can't get up, you must be escorted at all times.
She would be permitted to she would be permitted to go and scoot around campus, correct? Answer, with supervision, yes. She was independent of ambulation, correct? Answer, correct, but she also was a high fall risk as evidenced by her medical record in her 1823. So she did require some supervision because of her high risk of falling, because she's not capable of getting up on her own. We're talking about falls, not ambulation. If she falls, she cannot get up by herself. So she does need some supervision over her falls, whatever that means. She does not need supervision to ambulate. Again, it's kind of contradictory. And the scooter is one fall precaution, is the question. That's an intervention to keep her more safe, correct? I think it's an aid to ambulate. I don't know it as a fall prevention or precaution. I'm sorry we're running through these, but we just don't have the time, and it's important to get through this testimony. This is plaintiff counsel testifying or asking questions, getting to the issue of punitive damages.
You were right the first time.
So, okay. Punitive damages. Based on your 40 years in the field, this is coming from plaintiff lawyer, based on your 40 years in the field and knowing the industry and seeing everything you've seen in this case, do you agree that that's true, that they sacrifice resident care for corporate profit? It does appear that way, yes. Do you believe that the facility exhibited a reckless and conscious disregard for the safety of this case? Yes, I do.
And this is ED?
This is a current ED in
This
our
is
industry.
the plaintiff's
Correct?
section.
Still the same job?
Yes.
It's not the ED at that building, though.
No.
No, the ED in that building is wonderful.
I just don't, listen to the answer. I just don't think that they wanted to spend the money to lessen the risk of harm to people. Like I said, they could have removed the landscaping. I just don't think that they wanted to take any action or spend any money to make the area more safe. Question, well, other than remove the landscaping or put in surveillance, which we know did not actually view that area, what else are you saying the company did, the corporation did, that somehow was punitive in nature?
Oh, no, can I do this one?
Yes.
maybe they needed to have a staff member at the doorway so that they could monitor people coming and
Oh,
going.
yes. Every doorway, 22?
Every doorway.
More punitive damages. And
Can you
did
keep
it,
on my jury, please?
yes. Question, and did it appear to you that they simply chose not to do that to go for corporate profit over resident care, just like nurse so-and-so testified that she had observed? Yes.
And then we had a caregiver who literally saw this resident come, that she went to lunch. So the 6 hour period was blown out of the water, you know, she's out there for 6 hours burning in the sun. She goes out in the morning, she sends her son an email around, you know, what was it, 11 o'clock. She goes to lunch, she goes to the late lunch at 12, and then she's seen by a resident running her scooter or private towards her apartment building. And as to that testimony, she completely disregarded it, just decided, I'm not gonna believe it.
For the purposes of your opinion, you're going to disregard the testimony? Yes, I am. Do you agree that Miss So-and-so gave false, this is another, she's talking about another caregiver. Do you agree that Miss So-and-so?
She's talking about our ED.
Hmm?
She's talking about our ED.
Do you agree that Miss So-and-so gave false information in her deposition testimony when she spoke to DCF and when she reported this to the medical examiner's office when they contacted her? Answer, I don't believe that she was fully truthful. No. I think she was avoiding reporting to the state. I really do. Okay, now we talked about that you're claiming a cover-up, I believe, correct? I'm not saying a cover-up, I'm just saying that I don't think she was forthright. So going back to my question, you would agree that any standards that you discussed here today as being your opinion as to what is required by rules, regulations, and laws in the state of Florida for standard license ALF would also apply to all of your resident facilities? And she said yes.
And here's the issue with that, and I actually tried to protect the company that she was employed by, because this will come back in every case they have.
Yep.
And it is out there now for all of us. So the part of taking away from this is educating our administrators, our EDs, our RCDs. What do we do? You know, I mean, this was the most egregious testimony in 30 years of doing this that I have ever experienced. So we just need to make sure, you know, it's important that we know what we do, we advocate what we do, and I know you care about what you do, because this is not an easy profession, and you wouldn't do it if you didn't love it and have a calling. But this is real. Every question and answer on this board, I was there.
Can you go after somebody for this kind of testimony?
I could not, but it gets better.
Okay.
Well, yeah, and these depositions are public record. Plaintiff lawyers can find these easily when they're doing research on experts. So yes.
And that's the problem, and that's why you need to know that it is out there. This is out there as a standard of service. Again, I say standard of service, not standard of care. But this is out there. And this is particularly damaging to the company for which she continues to be employed, but it's also damaging to the rest of us. But this was my favorite one.
This is
trial testimony.
This is in front of the jury. Question from the plaintiff lawyer. And how much did you charge our law firm per hour to review the records? I charge $190 per hour. Question. And I believe you charged our firm $6,032. Is that correct? Yeah, that was a nice Louis Vuitton bag. Thank you. The plaintiff's expert.
Now, understand that our defense nurse expert, she actually rolled out OBRA back in 1987. She has a distinct qualification, and she runs a not-for-profit charity movement in Kenya to help women have jobs and have children get medical care. So this expert did it for a Louis Vuitton bag, but our expert did it to help people. All her money that she does for expert work goes to her Kenya project. So this was very disturbing. I mean, this is just disturbing, but you need to know it's out there. This is what this, and then they go on the media to say they want to change the rules that apply to us. You know, well, that's just recognizing that what she testified to was wrong. It was a lie. But it's out there. It's out there, we're all gonna have to deal with it, and it will be uploaded, and the plaintiff's lawyers will have it. So be aware. Okay, so, lessons learned. You know, daily observation, we need to be lobbying our legislature. You know, what does daily mean? If we have people, you know, checking people at meals, meds, you know, we got meals, meds, we got activities, we got all sorts of things that we are watching, we're looking, we know their routines, general whereabouts, that's routine. The 15-minute checks is absurd, and we need to make sure that we really do lobby the legislature to redefine, or actually just define, because it's not defined. Traveling independently in the community, that clearly means the community at large. You know, while we call our facilities communities, which they are, they're residential communities, the community in which that category is community at large. It means you can go to Publix if you want to pick up, you know, fried chicken there. Attendance, just know that you need to have documentation of education, because if you don't have that, then they're gonna say that people had a false sense of security because they had attendance and didn't know where they worked or did not work. So that's important. Surveillance cameras, that was a big issue in this case. Even though the surveillance cameras was because it was the independent living side, and we were having some thefts, which resolved. So we did an inquiry in regard to, you know, putting surveillance cameras in, which would not have shown her going in and out of the door in which she went. It was completely a red herring. Call system records. It's nice to know when people do call. But those records, they can go both ways. You know, they can go both ways. Jury trials versus arbitrations. If you're not using arbitration agreements, I strongly recommend it. I know that it's a controversial issue. If your defense lawyer focuses on selecting the neutral and not just accepting what if the plaintiff counsel suggests somebody, I can almost guarantee you it's for a reason. Really be careful of who the neutral is, whether it's a 3-member panel or a single person, that neutral makes the decision. That's it. So you need to make sure that person you trust. And if it's a bad case, you really want to make sure that person is reasonable. So, because there are cases out there that go rogue. I have been very, very, very fortunate and positive about arbitration proceedings. We have had great results on those, including unanimous defense verdicts for 3-member panel, which is almost unheard of.
Right, this case would be much different from an arbitration panel. A lot less emotion, you'd have an educated panel making a decision. But there's no arbitration agreement, so we were stuck with the jury.
Well, and we also had a terrible judge. So
We can't say it officially.
I'm sorry, the judge was perfectly reasonable. Dangers of the jury trial. Jurors have hidden agendas. You know, we found out in this case, you know, there was a split verdict for 8 hours. For 8 hours, they were arguing over whether we did anything wrong. Number 1 on the jury form. And juror number 2 beat the living daylights out of the rest of them. And we know that because juror number 1
Called our client.
Was she 1?
Yes.
Okay. Juror number 1 called our client and told her. The attorneys can't reach out to jurors, but the jurors can reach out to your clients. And they did, because she was that upset. And actually, when she came into the jury room, she looked at me, and she was literally this close to me. We sat this close, and she went, "I'm sorry." Oh, after 8 hours.
And the juror number 2, the bully, told her, reported to our client that she has been fired from her job for serving on this jury, and she was going to punish a company, and she's not leaving without a plan first. That's the danger of the jury system.
So arbitration agreements, it's really good. And have the right people sign them, please. And the right people, if you're not sure, if you've got a resident that has some cognitive disabilities, let them still sign it. You've got to be incapacitated. You know, and that's the plaintiff's burden. You know, have them sign it, have the family member sign it. If there's no POA, have a signing party. Have everyone sign it. That's my recommendation. And if you can get a guardian in place, if you don't have the right person, do it and then have them sign it again. You know, and I know that's a challenge. I understand that. Brian does guardianships, and I understand the challenges of that. But that's my recommendation, because arbitrations are so much better in my humble,
Absolutely. You have limited appellate rights, but we believe it's worth the risk. Guys, we had to run through this. We got through every slide. Sorry it was so quick. We only had 30 minutes. We're available to talk afterwards or calls or email, but this is serious, serious stuff and scary